the Q&A session. As you could hear, the recording has just started. Also, at the end of each panel discussion, we will be having a session on questions and answers, where you are free and actually encouraged to ask any questions you may have to our speakers. I think this was all in terms of housekeeping rules. We have activated the captions. So if you wish to see the captions, you can just press the button CC below. If there's anything that needs any question on the setup of this webinar, please feel free to ask our colleagues from Validity Foundation, Cenge and Axel, who are here in this room, and will be happy to assist anybody with any accessibility issue they may have. My name is Simona Florescu, and I am the Litigation Director of Validity Foundation. We are a non-governmental organization who have worked on strategic litigation for persons with disabilities for 20 years. In partnership with persons with disabilities, attorneys at law, and non-governmental organizations from Central and Eastern Europe, Validity Foundation has litigated cases before the European Court of Human Rights, before the European Committee on Social Rights, the UN treaty bodies, and the Court of Justice of the European Union. Today, we will take stock of some of the achievements of strategic litigation and some of the setbacks that we have encountered over the years. Most importantly, in this event, we look forward at the potential of strategic litigation and hopefully brainstorm on the added value of the European Union in this field, as well as on other procedures for international settlements. I will start by outlining the framework of this webinar and situating it within the wider context, and I will say a few words about strategic litigation and the relevance for the protection of human rights before I pass on the floor to our esteemed speakers this morning. I would like to start by saying that this event is organized with the support of the European Union, and it is in the context of the Litigate project, which addresses strategic litigation as a gateway to the rights of persons with disabilities in the European Union. We have partners from 5 EU countries, and the aim is to promote the enforcement of the EU Charter of Fundamental Rights with strategic litigation activities and to address the breaches of fundamental rights of persons with disabilities and in particular of persons with intellectual and psychosocial disabilities. This project has started in 2024, and the first aim was to understand how the EU Charter of Fundamental Rights and litigation before the Court of Justice could contribute to the protection of the rights of persons with disabilities. As some of you may know, the European Union itself is now a party to the CRPD. The CRPD is the acronym from the Convention the Convention on the Rights of Persons with Disabilities, and the EU is a party to the CRPD since 2011. And it is the first supranational organization who is bound by this instrument and has to uphold all the rights and obligations under the Convention. Also, it has to submit periodic reports to the CRPD committee, and the latest such review by the CRPD committee took place in March 2025. However, despite such commitments, a look at how the rights of persons with disabilities have been brought before the Court of Justice of the EU, and that is the Supreme Court within the European Union, the rights of persons with disabilities, the way they have been upheld by this court, is ambiguous, to say the least. The CRPD has been litigated before this court, but the litigation had a rather narrow focus. One explanation can also be that the wording of the EU Charter of Fundamental Rights only allows the application of this charter in the implementation of EU law. This means that if the EU has not legislated in a particular field, the EU Charter of Fundamental Rights will not be applicable. For this reason, and in light of this limitation, we have started the Litigate project with researching the areas of EU law which may be relevant for persons with intellectual and psychosocial disabilities and where the EU has legislated. We estimated that in these areas, the EU Charter of Fundamental Rights becomes applicable, and as a consequence, there is room for litigation before the Court of Justice of the EU. Our partners in Bulgaria, in Czechia, in Slovakia, and in Romania have looked at 4 specific areas. We have looked at the rights of victims with disabilities, we have looked at the right to vote, we have looked at EU structural funds and their role in the deinstitutionalization process in member states, and we have looked at freedom of movement for persons with disabilities. I will not now explain here our findings, but I would like to mention that they can be found in the Strategic Litigation Guidebook, which is available on our website, as well as on the websites of our partners. In this guidebook, we look at these 4 areas of EU law and explore how the human rights of persons with disabilities could be further enhanced through litigation at the Court of Justice of the EU. The guidebook also offers some strategies about building cases to the Court of Justice, and it situates this court within the wider international human rights law landscape. Now, before I close the introduction, I would like to say a few words about strategic litigation, as this is a concept that we will be mentioning all throughout this webinar, and it has formed the core of the Litigate project. Now, what do we mean when we say strategic litigation, and how is it different from ordinary litigation? Every case brought before a court is about settling an individual dispute. A person with disabilities bringing their case to court would want to see justice done and would want to defend their specific rights. However, strategic litigation is also about a wider aim, the aim of redressing systemic injustices, and in the case of persons with disabilities, about changing biases and stereotypes. This is where the difference lies. Strategic litigation has a wider aim. It is about a cause. It is not just about the case. And we are happy to say that in our engagement with persons with disabilities throughout the years, we have seen persons with disabilities becoming advocates for their cases, for their causes, and not just for their cases. This is the main issue to keep in mind when we mention strategic litigation. I think this was enough from me at the moment, and I would now like to open the floor and introduce our first speaker, Bart van Vooren, who will be talking about litigating the rights of persons with disabilities before the Court of Justice of the European Union. Dr. Bart van Vooren is an attorney at law, and he is a partner in Covington's Brussels office, where he leads a dynamic practice at the intersection of EU regulatory law, global health, and biodiversity compliance. In these fields, he advises pharmaceutical, food, and cosmetic companies on the complex EU global and regulatory and policy assignments. Bart also maintains an active pro bono practice, and this is where he and Validity have worked together. He has worked together on the rights of persons with disabilities, on LGBTQI rights, and refugee cases. Bart is widely recognized for his litigation experience before the Court of Justice of the European Union. He has represented both corporate clients and governments in more than 42 cases. As I have mentioned, he has also worked with Validity Foundation, arguing cases before the Court of Justice of the EU, and we are very proud to have him today discussing hopefully these cases and how the Court of Justice can influence the rights of persons with disabilities. Bart, you have the floor, and I think you would want to share your screen.
Yes, just clicking the share button now, and you should see it now. Do you, Simona?
Yes, yes.
All good? All right. Good. Thank you, everyone, for attending the webinar today and for inviting me, Simona, Stephen, and others. All right, let's jump right in. So what will I be talking about today? I'll just do a brief level setting and reminder about the Court of Justice. What is the court? What is it that we are talking about? I'll give you the two main types of procedures. There's very many others, but from a strategic litigation perspective, the main two ones that we are interested in are called direct actions. And the second is called a preliminary reference. And I'll give you some pointers on what these are, and then I'll give you examples, including the cases that we've done with our friends at Validity, as well as the European Network for Independent Living and some other cases. I'll briefly build on some of Simona's reflections about areas where you might be able to litigate. So that's what I mean with EU law is broad. And then some final reflections as well on strategies on building cases that bring you before the EU Court of Justice. So just some level setting. The Court of Justice of the European Union is a general name. That actually comprises two courts. So we will be talking about the General Court of the European Union. You can see that here in bold. Let me just actually create a little pen here. So I think I can write. Can I highlight things? Oop, that wasn't the intent. Anywho, so yes, I can write. So here, the General Court, as well as what we call the Court of Justice or the ECJ. And you can see that they can rule on action. So that's what I mean with direct actions, either brought by a member state, an EU institution, so the Parliament, the Commission, the Council, or a natural or legal person, such as a person with disabilities. And so that's the first set of legal proceedings that we will be talking about, direct actions against the EU institutions and acts of the EU institutions itself. So that's really important one, legally binding acts of the EU institutions. And those are handled by the General Court. So that in principle, at least. And then you have the preliminary reference, which are handled by the Court of Justice or ECJ. And those are, as you can see there on the text, at the request of national courts. So you don't go there directly. You don't file yourself a case directly before the ECJ on an interpretation of EU law or the lawfulness of certain EU law, but you have to go through a national court that then sends a preliminary question, preliminary in the sense that before they can solve the case before them, they need to clarify an issue of European Union law. So those are really the two big distinctions to keep in mind. General Court, first instance, direct actions against acts of the EU institutions. And the second, Court of Justice, appeals against first instance or preliminary reference. So those are the two key avenues to keep in mind for CJ-EU strategic litigation. The next slide is a bit more detail on direct actions. So I mentioned direct actions can be brought by member states or EU institutions. You see that here. And they can be brought by natural or legal persons. You can see there that I make a distinction between privileged applicants and non-privileged applicants. Privileged means that a member state or an EU institution, such as those mentioned, they do not have to prove standing. And that's a really important one because standing, the ability to bring a case, is a big hurdle when you are a natural or legal person, a non-privileged one. Why? Because you can see there highlighted in yellow when you are a natural or legal person. So when you are Validity or European Network Independent Living or a person with disabilities seeking to enforce their rights directly, they have to prove that they are directly and individually concerned by an EU act or directly concerned by a regulatory act. I'm not going to go into super detail today about these rules of standing because there's lots of case law, etc. But it's a really big and important difference. You can't just access the EU General Court directly when you want to challenge. You have to prove that it affects you, whatever it is that you are wanting to challenge. Defendants, typically, for instance, you see there validity versus European Commission. Typically, you would challenge the European Commission or maybe a body such as the European Medicines Agency, probably less relevant here. Now, what can be challenged before the EU General Court is either EU legislation or other acts like regulatory acts, individual acts. EU legislation, as a matter of principle, cannot be challenged by non-privileged applicants. Meaning concretely, if there is a piece of EU legislation, a regulation or directive that we as validity or as individuals are unhappy with, we are 99.9% likely not to have standing to challenge it directly. And believe me, I've tried, which is why some people sometimes chuckle, hey, Bart, you just like to collect inadmissible cases. But sometimes, and we'll talk about that, even an inadmissible case can be a win. But of course, also non-legislative acts, implementing acts. Let's say that there is a specific decision aimed at validity. Validity, you don't get EU funding anymore. Purely theoretical, I hope. Then that might be an act that validity could challenge directly before the court, the EU General Court. So direct actions. And now I'll give you two examples of direct actions, and I'll give you some of our arguments, some of our thinking, and how this fits into strategic litigation. So the first case I want to talk to you about, you see there on the screen, is validity versus European Commission, together with the friends in Bulgaria, the Center for Independent Living. And the issue essentially was a funding, a project in Bulgaria with, I don't know how they called it exactly, was it co-housing, supposedly to deinstitutionalize, but in essence on the ground still to continue the segregation and institutionalization of persons with disabilities, which of course we argue violates the UN Convention, UN CRPD, Article 19 on living independently and inclusion in the community. And so the question then, of course, is this is a really complex system. So you have this national specific project, but there's EU money being used. How does the EU money go there? How is it managed? It's under a system of shared management, which honestly creates complex issues of who actually gets to do what when this specific project violates EU law. Is it the responsibility of Bulgaria? Is it the responsibility of the European Union? So we had to think, okay, we want to really make a point that this EU money should not be used in violation of the UN Convention, the EU Charter, and EU law in general. So what we did is we sent a letter to the European Commission inviting them essentially under a specific EU regulation to halt that funding for that project. And our thinking was, okay, if they do not halt or they fail to reply, we will submit a failure to act procedure. Now, I've not gone in too much detail about the failure to act procedure, but it's basically a form of a direct action whereby the court can then declare that that the failure to act has been unlawful. Now, I'll say it up front. You see there in high big letter, the appeal is dismissed as manifestly unfounded. So like Simona said, there is the case and there is the cause. On the case, we failed. At least if you look at it from the perspective of, did we get a declaration that there was a failure to act? No, we didn't. It got declared as inadmissible. Now, even the fact that it got declared inadmissible, and you see there paragraphs 47 and 48, which really frustrate me still to this day. So I'll get a bit more into the detail. So like I said, for a direct action, an act needs to be legally challengeable. And the Commission said, it is not a challengeable act. You, validity, you are not directly and individually concerned. No one at validity will be expected to stay in that co-housing. You, validity, are not the recipient of the money. And actually, it's not us, the EU, it's the member state who is responsible. And they also argued, well, if it's not EU money, then Bulgaria would use their own money. So it doesn't really matter that we provide them funding. So all these kind of arguments, we said, well, we are an NGO representing or constituted lawfully to represent the rights of persons with disabilities. And we argued that, well, those persons may, due to fear of reprisals, or because they are under guardianship, or simply because of their intrinsic disability, are not able to represent themselves. So we, as Validity, should have the right to bring this case. So the cause was actually double. It was about the money being spent in violation of Article 19 CRPD, but it was also about who actually gets to ensure that justice is done in the specific case of persons with disabilities, with mental disabilities. And then if you look at paragraphs 47 and 48 there, well, the court said, well, Validity's argument that persons with disabilities that would be directly and individually concerned, i.e. because they will be, in the co-housing that violates their CRPD rights. The court said, well, if they were prevented on account of their disabilities or fear of reprisal from bringing an action against that latter, that does not mean that Validity should have been granted standing. So, and then in paragraph 48, they said that any difficulties, however serious, faced by persons with disabilities to challenge a measure that is direct of individual concern to them, does not warrant an action being brought by Validity, even if it's not of direct and individual concern. So we had argued, look, there is the CRPD, access to justice. There is the UN Charter on the EU Charter on access to justice. In our specific case, those fundamental rights of access to justice should give Validity standing before the General Court. And on appeal, the Court of Justice said, no, the Charter does not override the standing rules of 263 of the Treaty on the Functioning of the Union. So we lost, but at least the fact that the Court of Justice made, among others, this glaring statement about the relationship between access to justice before the Court of Justice and the international human rights instruments is then, I hope at least, useful in advocacy to demonstrate that, well, something is wrong there. A second point on strategic litigation, but I see that my time is running short already, I think, Simona. So this is a case that, as you can see from the title, we've brought in the name Covington and myself. That was actually what was the background. In essence, the way that the procedure for adopting regulatory acts, so not legislation, but implementing acts, delegated acts, all these kind of very specific decisions, the way that these are adopted essentially means that you do not know which member state cast what vote. You can see there on the left-hand side how many voted in favor, 22, how many against, and how many abstentions. Now, in this specific case that I am quoting there, we knew that one member state said absolutely nothing, and that rather than counting this as an abstention, the Commission counted this as a yes vote, as a vote in favor, which in EU lawmaking is really important, because if you have a blocking minority, that can actually block the adoption of a decision. And so we requested access to the votes, and we basically argued, look, in a democratic society, the EU says you are based on the rule of law, democratic principles. These votes should be public. We, as individual EU citizens, should be allowed to check how countries voted. And so we challenged the refusal to disclose the votes. We won. The General Court said you have to, you cannot just presume that votes should remain secret. This is on appeal. The Commission, of course, appealed against this. We actually have an Advocate General opinion that says, yay, the Commission appeal should be dismissed, but the Advocate General did not agree with my argument, the cross appeal, that votes in a democratic EU should always be in the public domain. Now, moving on, back to strategic litigation. This is one that I also wanted to point out, because you see here a case, Kingdom of Belgium versus European Commission. Now, I mentioned before that there are privileged applicants and non-privileged applicants. In the previous two cases, Validity, me, Covington, CIL, are all non-privileged applicants. The benefit here, in this case, was that the Kingdom of Belgium is a privileged applicant. They do not have to prove standing. So the case is immediately admissible from that perspective. And why do I call this the Holy Grail? Because there may be instances where you as an association, or in this case as a company, are able to convince a member state or an EU institution to bring a case themselves, which avoids the whole procedural obstacles. So that's what I mean with who brings the case. If you can convince they to bring it on your behalf, to fight for the cause for you, well, then that is, I consider to some degree the Holy Grail. Also because, you know, having acted for companies, for trade associations, and for member states. So I've represented Belgium before the EU Court of Justice. In my days, in the earlier stage of my career, you really feel the difference in terms of when you are there as a member state, you're taken far more seriously. Your arguments are really, you know, you're taken far more seriously in essence. Now again, here this case was also declared inadmissible, hence the joke that I collect inadmissible cases. But the goal here, the cause that lay behind it, was to undermine the Commission initiative to create an EU-wide liberalized online gambling market, which we really didn't want. I can write a chapter in my memoirs about the background there. But the EU started with some soft law and was a plan to liberalize gambling. In my view, clearly a bad idea. And so we filed this litigation through them, and it was declared inadmissible, fine, but still the EU initiative was halted. So that was, in that sense, a win for the cause, if not a failure to the case itself. So those are examples of direct actions directly against EU measures that you want to challenge through different actors, me, Validity, member states. What I will now briefly discuss are preliminary rulings. So as I said, preliminary rulings are fundamentally different because they start at national level. Bulgaria, Hungary, Belgium, what have you. It's really up to the discretion of a national court to ask a question to the Court of Justice. So what you need to have is an individual dispute that raises a question of EU law. And there's two types of questions that can be, let's say, elevated to the Court of Justice. One is EU law valid itself, or, and more common, the interpretation of EU law. What is the impact? If EU law is declared invalid, and maybe that's a bit confusing to call it here validity, but in essence, it means that the unlawful EU act is considered to have never existed, and this is across the EU 27, so erga omnes. The same with interpretation. The Court of Justice interprets EU law in light of, for instance, the Charter of the or the UN CRPD. This is all very theoretical, so I'll just jump right in with another case that we handled. Some background on this case. This is a Polish case, so this was very much against strategic litigation, and I want to highlight this is certainly not my merit. We came in before the Court of Justice, but essentially you had a self-employed audiovisual contractor in Poland, somebody who, you know, edits videos and sound and like is good with images. He's a gay man, and around Christmas, he made a funny video, to be honest, singing to Mariah Carey together with his partner, advocating for LGBTQ plus rights, and there was, you know, two men kissing, etc. So which was considered to, especially back then, you still had a very conservative Polish government, kicking the shins of the government. This man worked for the public broadcaster of Poland, so TPSA, and he had recurring contracts. So every couple of weeks or every week, he had, like, you know, a constant flow of requests, meaning that he was self-employed, formally speaking. And when that video came out, he suddenly didn't get contracts anymore, even though he was very involved, got good reviews always. Suddenly, they disconnected him from collaborating with the Polish public broadcaster. And so Polish lawyers brought a case before the Polish National Court, essentially saying he's being discriminated, among others, and they invoked national law, but also EU law. And so the question that came then up was, you have an EU directive on equal treatment in the workplace, but it refers to employment. And so some of the questions on interpreting EU law in the preliminary reference that the National Court asked was, does employment cover also like self-employment, you know, the sequence of contracts? Other more fundamental issues, the Polish government said, well, we have freedom to contract. And if we don't want to contract with this person, that is our good right. Of course, you have a clash there between, you know, fundamental principles. You have on the one hand, the freedom to contract, and on the other hand, the right not to be discriminated based on anything, in this case, of course, sexual orientation. So a balance between those two. This was brought to the Court of Justice. We helped with drafting the submission, and you see there a brief summary of the outcome. The outcome was all around positive in the sense that the court gave a very broad interpretation of what does it mean to be employed. As long as there is a degree of stability between the legal relationship, you are considered within scope of EU law for this protection. So that is also one thing that I want to emphasize here. EU law is extremely broad, and you may simply also want to argue that something is covered by EU law as part of considering strategic litigation. The court confirmed that the exact legal form of the employment also does not matter. And they also made a pronunciation on balancing the freedom to conduct a business, or the freedom to contract, or the freedom with whom you want to do business is not absolute. We already knew that from other case law, but in essence, they say this freedom to contract in balance with not being discriminated based on sexual orientation, on balance, and quite self-evident, if you ask me, the prohibition on discrimination trumps the freedom to contract. Now, I say that's self-evident, but actually there's a lot of backstory here, because we actually knew the judge referring this from the Polish court was a relatively young judge, and you could even argue who needs a preliminary reference. This is so obvious, but we actually knew that the judge, especially in this conservative context, had fear of reprisals, that he would lose his job if he would himself decide basically wrong the public Polish TV and agree with the discriminated gay man. So he referred to the Court of Justice in order to be able to say, look, this came from the higher court. It was not just me. So a bit of the background, but and I also remember when we went to plead the case, the agent of the Polish government, that lady really had a bad day in court, because she came afterwards and told us, I really hope you guys win, and I'm really sorry I have to argue this. This is my government telling me to do this, but I fundamentally disagree with them. Anywho, so this is an example of a preliminary reference. And I suspect even, and I don't recall exactly, but I think that the video was also made to some degree to trigger the case. They went so far. So a hat tip to them. And that, of course, raises one of the issues in strategic litigation, the people at the center of this litigation. There is the cause, but there is also the case, and there's the person behind the case, the reprisal, the impact on that person's life. What will this case do even to them? So that is something that, you know, I remember over the years, Stephen and others and Simona and I have had to have deep discussions on in the cases of strategic litigation. So this is really something to take into account. Not to take too much time, but I still wanted, you know, to make this point. EU law is very broad, so there is, let's say, a bit of creative thinking necessary when you want to build a case, a preliminary reference, or a direct action. Now, from my professorial days, I did a PhD on the interaction between EU law and international law. So I love this whole area of the relationship between the UN Convention, the CRPD, and EU law. There is, in general, look, the EU is a party of the UN CRPD. In the EU hierarchy of norms, international law stands on top, then the treaties, then secondary law. And so if we can work together to find cases whereby we can make the UN CRPD quote unquote enforceable, there is some case law on that, but at least interpret EU law in line with the CRPD, any article, whether it's 19 or 16 or what have you. So those, to my mind, there is still some area for exploration there. Then, of course, EU primary law, by which I mean the treaties and the charter, but Simona has already flagged that the charter only applies to member states when they are implementing EU law. But again, I think you can make fairly broad arguments. And then secondary law, I mentioned already the Equal Treatment in Employment Directive, but there is recently the European Accessibility Act as well that requires service providers, manufacturers of products to make sure that they are accessible across multiple sensory channels, also that they are understandable for people who may need it, etc. So overall, there is a lot of room for creative thinking and strategic litigation to bring together both national law, EU law, disability procedure, human rights law, etc. Some final reflections. These kind of cases require long-term planning. I would always start with what is it that you want to achieve? What does a win look like? I really liked, Simona, when you said the case and the cause. I'm definitely going to use that one going forward. Then thinking, what is the EU legal issue? I still think that, you know, you can argue that almost any national issue is somehow touched by EU law, by acts of the EU, by international law as a source of obligations. So what we like to do also as a law firm, and some of my colleagues are on the call as well, is just brainstorm together with you, like find an original argument that, you know, passes the red face test. And that's also something that I really appreciate about Stephen. He's also a very creative thinker on how different laws interact. So I think those are, you know, first two things that you want to go through. And then, of course, who will act? The individual, validity, or can you convince a government or an EU institution? Like I said, when it's an individual, all kinds of personal considerations. We don't want to jeopardize the person's reputation, livelihood, or anything else. And then how can we get there the best way? National courts, not all national courts easily refer to the Court of Justice, others do. For instance, in France, I have found it harder to get a preliminary reference up to the CJEU, but when they do, when the Conseil d'État refers up, it is taken more seriously in Luxembourg. In Belgium, it is slightly easier, and I've noticed judges just copy-pasting the preliminary reference as we ask them. So you need to be quite familiar with that as well, or can you go directly to the court? And I think it's a big picture thinking. Litigation in itself is important, but if you can then have academics writing as well, you think of it in public policy terms, communications terms, also really important when you think about strategic litigation. And of course, this is a team effort. And maybe to end, I think that all the cases, most of the cases that I refer to, no, well, we won the gay rights case, but we lost quite a few as well. So like I said, we certainly don't win them all, certainly not the cases, but you know, the arc of the moral universe is long and it bends toward justice. And I really truly believe that. So let's work together to make that reality. So do get in touch. Happy to do brainstorming sessions on what might be possible under EU law. And now I think, Simona, over to Cara. I will stop sharing my screen.
Thank you, Bart. Thank you very much for this presentation. It was very, very interesting to hear you, and also to hear you mentioning some of the cases we have litigated together and some cases we have not litigated together, but help shape the thinking of people that consider litigation in this field to understand what the impact may be. And also, I think it's important to know that winning the case, it's not always the ultimate aim. Even when a case is lost, simply putting the issue on the agenda can achieve change in meaningful ways. Now, I will not continue with this because I would like to give the floor to our next speaker, but I do wish to mention that there will be space for questions and answers. So please feel free to leave the questions in the Q&A section, and I will read them out loud for Bart at the end of the next presentation. For now, I would like to give the floor to Zacharoula Katsigianni, who is an attorney at law at the Greek Council for Refugees. She is also a PhD candidate at the Hellenic Mediterranean University and an associate professor at the Hellenic Police Officers Academy. She has expert knowledge and extensive professional and academic experience in the fields of migration and human rights law. Her area of expertise includes legal representation of persons in need of international protection before national court, before the Court of Justice of the European Union and the European Court of Human Rights, and she has brought her valuable experience to strategic litigation at both the national and European level. Zacharoula will be talking to you and to us about the rights of asylum seekers and how she has worked in this field. And we have invited her because this area is a very rich area of EU law where the Court of Justice has regulated, and I think it can have a very powerful impact for persons with disabilities and litigation for persons with disabilities. Zacharoula, you have the floor.
Thank you very much. Good morning, everyone. Thank you for the invitation and the opportunity to be here with you and for the kind introduction, of course. Now I'm going to put my presentation. Let me see. Can you see that?
Yes, we can see.
Yes, and this is a full screen. My presentation is about lessons learned from litigating the rights of asylum seekers at the Court of Justice of the European Union and the European Court of Human Rights. As Simona said, I'm lawyer at the Greek Council for Refugees, which is the oldest non-governmental organization in Greece, which was founded in 1989 and provides free legal and social services to persons in need of international protection. Especially we as a lawyer, we provide legal representation not only before the national courts, but also before the European Court of Human Rights and the Court of Justice of the European Union. Over the past years, we have been involved in litigating many cases before these two European courts. And these cases can be typically divided into 5 categories. Oops, I'm sorry. Okay. The first one is the safe third country concept. The pushbacks cases, reception condition cases, detention of children, and family reunification of recognized refugees in Greece. Through this through these cases, our strategic litigation goals can be summarized as follows. First of all is the legal change or proper interpretation of law or proper application of law in order to ensure that legal protections and the legal rights as foreseen and provided for in international instruments are not just theoretical but also effective in practice. The second goal is, of course, the policy change in order to compel all the actors to amend their policies. The third goal is accountability and transparency in order to hold actors accountable for misconduct or abuse of power. And our final goal, among others, is empowerment and mobilization in order to give voice to marginalized communities as persons with disabilities or stateless persons and in general refugees, and raise public awareness about them. Through this presentation, what I hope to share with you are the insights, actually the challenges and the impacts while litigating asylum seekers' rights before the European Court. I will start and I will focus on the Court of Justice of the European Union. As Dr. Bart van Vooren said before, one of its main functions of the Court of Justice of the European Union, which is relevant to our work, is the preliminary ruling procedure, where national courts can refer questions to the court when the interpretation of EU law is unclear. A characteristic example here in Greece is the EU-Turkey deal of March 2016, according to which the asylum application of irregular migrants arriving on the islands, on the Greek islands, after the 20th of March of 2016, their applications can be rejected as inadmissible and they can be ordered to be returned back to Turkey. Okay. Since 2016, as lawyers, we witness a shift and a systematic rejection of the majority of their applications, both at first and second instance. So on the basis that Turkey was deemed a safe third country following the EU-Turkey deal. In response to this practice, we were filing applications for annulment before the Greek administrative court, explicitly requesting the referral of preliminary questions to the Court of Justice of the European Union about the interpretation of Article 38 of Asylum Procedures Directive, which concerns the third country concept. Okay. However, in practice, what happened in practice was that national courts systematically ignored or failed to even respond to our requests. So we had a lot of rejection by the courts, rejective decisions, and no preliminary questions were ever submitted. This experience highlights the reluctance and the unwillingness of national courts to refer questions to the Court of Justice of the European Union. Thus, we can say that although EU law provides for a uniform interpretation via the preliminary ruling procedure, and at the end of the day, the right to access to an effective remedy, in practice, this access to the Luxembourg court is blocked by our national courts because they are unwilling to engage. On 22nd of September 2017, the plenary of the Greek Council of State, it is the highest administrative court in Greece, was asked, among others, to rule upon, for the first time, for the qualification of Turkey as a safe third country. It rejected the applications for annulment of 2 Syrian nationals, whose applications for international protections had already been dismissed as inadmissible on the grounds of safe third country consent, and they had been already ordered to be returned to Turkey, as they did, actually. The court was asked, among others, to refer to the Court of Justice the following issues via the preliminary procedure. If the ratification of the Geneva Convention without geographical restriction is a prerequisite in order for a third country to be considered as safe, the second question was if the temporary protection that is provided by the Turkish authorities can be deemed as equivalent to the Geneva Convention protections, since temporary protection status does not provide all the rights that are enshrined in the Geneva Convention. And the third question was if the third country can be considered as safe, where there is a possibility to withdraw at any time the temporary protection status with a decision of the Council of Ministers, which means by an executive state authority, and not be following an individualized assessment. What happened is, of course, the rejection of our request, with a narrow majority of 13 judges over 12, stating that there was any other reasoning, but that there is no reasonable doubt of the meaning of Article 38 of the APD regarding the safe third country concept. Thus, there is no reason to submit an application for a preliminary ruling. What happened in next is that the majority of applications for international protections kept being rejected on the grounds of the EU-Turkey deal, and all the applicants were forced to be returned to Turkey. So a great opportunity, we can say, that for receiving useful insights by the European Court on the meaning of the Article 38 of APD, on which the European judges had not ruled so far at that time, was missed. On the contrary, what happened in the next, on 3rd of February 2023, the Greek Council of State was called again for the second time to rule upon the joint ministerial decision that the Greek state had already issued, designating Turkey as safe third country for 5 nationalities, for Syrian nationals, for Afghan nationals, Somalis, Pakistanis, and Bangladeshis. That time, it was requested. It was also requested to exercise its right, its discretion, to send a preliminary request to the Court of Justice of the European Union for a lot of questions about the Geneva Convention, about the protection status, if it is equivalent, as we have already done in 2017. But it decided to refer the case only due to the objective fact of the cessation of payments to Turkey by Greece since March 2020. The court has been requested, the European Court, has been requested to clarify whether under Article 38 of the APD, read in light of Article 18 on the right to asylum, the assessment of possibility of readmission should be made upon designation of a country as general safe, upon the resignation of the individual asylum application, or the execution of the decision of return to the third party. The court, I'm sorry, I don't know if you can see. Okay, the court on 4th of October 2024 ruled that as regards that Article 38 does not preclude a legislation of a member state, in our case Greece, classifying a third country as generally safe if that country has suspended the admission or readmission of those applicants. But when it comes to individuals and individualized assessment, where it is established that the third country, in our case Turkey, who has already been designated as generally safe by a member state, does not in fact admit or readmit the applicants for international protection, that member state cannot reject their applications for international protection as inadmissible, and what they have to do, the national authorities, are to examine their applications on the merits. The courts, therefore, the decision on the existence or not of the possibility of readmission to the third country becomes a prerequisite, according to the European Court, prerequisite at the stage of issuing a decision and on the asylum application, and not at the stage of execution, as this has been the practice of the Asylum Service and the Appeals Committee since 2016. The court's judgment is of major importance, we can say, as it overturned an arbitrary and abusive practice of the Greek authorities and of the Greek courts, of course. What happened next is that on 21st of March 2025, the plenary of the Greek Council of State complied with the decision of the European Court and annulled the joint ministerial decision designating Turkey a safe third country. But a few days later, a new joint ministerial decision with the same content was issued by the government, designating again Turkey a safe third country. Just yesterday, they referred to me a case of a woman from Syria, the asylum application of whom was rejected on the grounds of new JMD, not taking, as you can understand, into consideration the binding decision of the Court of Justice of European Union, and afterwards the decision of the highest administrative court of Greece. I'm sorry. Another illustrative example demonstrating the obstacles to effective access to the European Court concerns the European list of safe third countries and safe countries of origin. Access to the European Court, in my view, will be extremely difficult regarding the examination of legality of European list of safe third countries and safe countries of origins. According to the asylum procedures regulation, which is going to be in force as of June 2026, according to Article 6 and 62, the possibility to adopt common list at European level of safe third countries and safe countries of origin was introduced. Currently, national lists may be this list of safe third countries or safe countries of origin may be litigated and contested before domestic courts, as I told you before, as was this the case in the Greek asylum system. A common list, nevertheless, common list based on the regulation, which is European Legislative Act, is directly applicable in the legal orders of the member states, will not allow national courts, as you may understand, to directly rule on the safety presumption and on the safety criteria with respect to individual countries that will be included in this list, as this would entail a review of the legality of an European Legislative Act, which is the exclusive competence of the Court of Justice of the European Union. So, national courts will no longer be competent to directly assess and rule on these cases. Asylum seekers, therefore, right to access to an effective remedy will be affected. As non-privileged applicant, as was said before, must meet highly demanding rules. Specifically, an applicant must prove that an act, a legislative act, is of direct individual concern to him. However, in the case of the common list of safe third countries and safe countries of origin, it is crucial to note that the regulation is in no way addressed directly to applicants for international protection, but only includes the countries considered as safe. So, in that respect, it will be extremely difficult for an applicant to prove and establish that the inclusion of a country in the common list per se is in direct individual concern to them. The added value of accessing the Court of Justice of the European Union can be summarized as follows. First of all, preliminary ruling before the European Court is not just a technical procedure, it's a tool to push national legal system forward toward compliance with EU law and values. Second added value would say that it's a uniform interpretation of EU law Clarity and consistency can be ensured. Stronger protection on fundamental rights, as the European Court is independently of domestic acts independently of domestic political or institutional pressures. This have binding effect. And of course, the last one is structural impact, that even one well-targeted reference can lead to changes in legislation and on national administrative and judicial practice, as happened actually here in Greece. I would like to tell you, to share with you a few words about the European Court of Human Rights. As an organization, we handle a large number of asylum cases. And this is the reason that we are in a unique position to observe systematic and systemic practices by the national authorities that not only raises concerns about the compliance with the European Union, but constitute violation of European Convention. For example, as regards pushbacks, you can understand that the issue that is raised is obstacles to assessing the asylum procedure, and as a result, there is a violation of the principle of non-refoulement. Detention of children, there is automatic or prolonged detention of them. As regards reception conditions, we have observed poor reception conditions, especially on the islands, and lack of procedural guarantees. And as regards family reunifications, the national authorities tend to interpret strictly the law, and they do not provide any alternative solutions. For example, that pushbacks, as a result of plenty of applications and interim measures concerning pushbacks that we had already submitted to the European Court of Human Rights, for the first time in a Greek-related case, scheduled an oral hearing for ARE versus Greece. The ECHR, for the first time, ruled and accepted the systematic practice of pushbacks by the Greek authorities of third country nationals from the Evros region to Turkey, and that the penal complaint is not an effective remedy because due to the ineffectiveness of the criminal proceedings here in Greece. As regards JRJ versus Greece is not our case, but in that case, the European Court observed and ruled, accepted the systematic practice of pushbacks at sea. As regards detention of children, the case of TS and MS versus Greece marked a turning point in the protection of unaccompanied minors in Greece. On 21st of March 2019, the ECHR issued an interim measures ordering Greece the immediate removal of the applicant from the police station. This was the first time that the court issued such an order to Greece, setting a precedent for subsequent interim measures concerning detained and accompanied minors awaiting their placements. These decisions, all these decisions of interim measures and of the application afterwards exerted significant pressure on the Greek state and the Greek national authorities, and of course played a critical role in the eventual abolition of a practice of protective custody of unaccompanied minors in Greece. Yes. Do I have 5 minutes more?
Maybe 2 minutes if possible.
Yes, I will be quick. The court reaffirmed this position in a later judgment that was issued only a few days before in MY and others, further underscoring the incompatibility of the detention of children with the European Convention. As regards the reception conditions, you all know MSS case v. Greece. The Committee of Ministers of the Council of Europe acknowledged on 12th of June of 2025 that significant progress has been made, so it closed the supervision procedure. Nonetheless, this decision of the committee concerns the deficiencies of reception conditions on the mainland. So serious shortcomings and deficiencies remain according to the Committee of Ministers, of course, according to the European Court of Human Rights, on the Greek islands. Especially when it comes to Samos Islands, to close control access center of Cross, etc. Because as we have observed, there are many deficiencies and violations as regards reception conditions and access to basic services. The last one is family reunification. All these three cases are pending before the court. We're still waiting for the decision by the court. They are the first ones that have been brought before the European Court due to non-provision of alternative solution when it is objectively impossible for refugees to provide the required document. So the central legal issue is that the refugees should not be expected to fulfill impossible requirements to assess the right of family unity, as this is asked by the national authorities. That's all. Thank you for your attention.
Thank you very much, Zacharoula. Thank you for this wonderful presentation, and I hope it really inspired the audience to look at other areas of law and how the EU law has contributed in this field. We have now a short time for questions and answers. Normally we should take a break in about 5 minutes, but if there are any questions, I would like to give the floor to the attendees to ask you if they wish to have a question. I see a question from Anna, and she's asking, has the case law since the adoption of the CRPD led to any changes in the standing requirements before the General Court, or have these requirements remained unchanged? Any dynamics? This is one question. Perhaps you could reflect on it, and I would like to give the floor to Vladimir Mirchev as well, who has a question as well. Ideally, we can collect the questions and then you both could have a reflection on those. Vladimir, would you want to come in with a question?
Oh, I'm sorry, I just raised my hand by mistake. I apologize.
No worries, no worries.
Well, I'm happy to pick up Anna's first question and then also her second question, because actually that's something that I wanted to ask Chiara as well. So Anna first asked, case law since the adoption of the CRPD led to any changes in the standing requirements before the General Court, or have they remained unchanged? Any dynamics? I certainly don't have a view of the entire case law on the CRPD, and maybe Stephen, he probably has a better view, but certainly that was a key issue in the validity case. And the rules on standing before the EU General Court, I think, have been one of the most, let's say, set in concrete a procedural element and a major obstacle, in essence, for multiple reasons. The General Court or the judges see this as a way of controlling the docket. I think that if they would, let's say, open the rules up, there would be a flood of cases, and they may not consider that desirable. That's almost a judicial policy decision, one that you can question. Certainly, I think in the view of rights of persons with mental disabilities who have no other means of being represented than through a third party. I think I remember a conversation that me and Stephen once had a while ago. Yeah, we should just set up a policy project to have the treaty change. That's the only object that we can do here. So that's maybe something to explore. Then, Anna, you asked also a very good question. If domestic courts consistently avoid making preliminary reference, are there any instruments available to NGOs to address this practice? And that's actually a question that I wanted to ask also, Chiara, to you. Have you undertaken any initiatives? Because in a way, it is a violation of EU law not to refer questions when a court should have referred questions. Now, what are the instruments? It's far from obvious. I was thinking as you were speaking, Chiara, like, a complaint to the European Commission. Pretty teethless, but they might then start an EU pilot and an investigation and then an obligation. And if they don't do it properly, you go to the European Ombudsman and all these kind of things. I don't know if you've tried that. And then maybe that was also my question to Chiara. I didn't fully understand when you said the rules on standing in a direct and individual concern in relation to designating of safe countries. I didn't fully get what is the EU legal basis, because I was thinking maybe that's something where we can do some creative brainstorming, that there should be standing. Yeah, that was my own separate question as you were speaking. So, Chiara, over to you.
Okay. When it comes to the questions about if there are any other legal instruments as regards preliminary references, what we do at the national level is, of course, to make a lot of interventions before the Greek ombudsman, but this is not enough. Because even after Greek ombudsman is intervened and asking for compliance with the EU law and international law of human rights, national authorities are unwilling to be complied with the law. So what we do is to address the European Commission. We cannot say, as far as safe third country concept is concerned, the European Commission almost immediately referred to, let's say, decision to the Greek authorities that they have to comply with the reception with the fact that they have to examine the applications of Syrian nationals, of Afghan nationals, of nationals from Bangladesh, from Pakistan, and from Somalia on the merits, since there is an objective fact that Turkey has seized since March 2020 the returns from the Greek territory to its territory. So it ordered. It decided that the Greek authorities have to proceed with examination on the merits of their applications, something that was not happened in the majority of the cases. So, as you know, we cannot challenge the rejection decision of the administrative court, against according to which they decided not to refer a preliminary request to the court. So what we do is to address to the European Commission, the Greek Ombudsman at the Greek level, at the national level. When it comes to the list, to the safe third country list, what I mean is that this list will include just the safe, the countries, the third countries that are considered as safe third countries or safe countries of origin. We're not sure if they will contain specific characteristics of specific elements that will be addressed to specific group of people, let's say, okay, that they are going, on which they can be based in order to approve and to establish that this list, and including a country, let's say, that is considered to be safe in the European level, will affect him in a direct way. I don't know what will happen, but I think that it will be very difficult to challenge the European list before the European Court of Justice. I'm sure for that. Because this list will include only the names of the countries that are considered to be safe. I think, I don't know. We will wait.
Thank you. Thank you for this. And thank you for the questions. I'm afraid we will have to break now because we are slightly over time, and I would like to come back at 11:30 after the break. Before we close, I would like to thank you both for your wonderful contributions. And I would also want to highlight to the participants that it is important to keep the Court of Justice in mind. And I think, and you both mentioned this in your contributions, the Court of Justice can be suitable also for designing litigation strategies. It is a long-term process, but because of these indirect proceedings and the preliminary references proceedings, it is suitable to think of cases. And the case that you've mentioned, Bart, on LGBTQ plus, was a design case specifically to tackle a legal issue that existed in Poland at the time. This is something that persons with disabilities, organizations of persons with disabilities can do as well. So what I would say, think of things that you think must be changed, and then we can discuss together how we can achieve change by using strategic litigation and using the Court of Justice of the EU. As you both highlighted, it's not an easy process, but it is something that we can try to achieve. For now, thank you very much. We will break and we will resume at 11:30. Thank you all. Good morning, everybody. I think we can resume the webinar. It is my pleasure to introduce to you our next speaker. And in these next sessions, we will be discussing about strategic litigation for persons with disabilities from a broader perspective. Professor Dr. Markus Schefer is Professor of Constitutional and Administrative Law at the University of Basel, Switzerland. His specializations include constitutional law and human rights, and in particular, disability equality law. Professor Schefer is a member of the United Nations Committee on the Rights of Persons with Disabilities, and in this capacity, he has worked on the EU periodic report to the CRPD Committee. Professor Schefer will talk to us in this capacity today, and he will be discussing about the role of individual communications procedures in advancing the rights of persons with disabilities. Thank you very much for joining us for this webinar, and you have the floor. Thank you.
Thank you, Simona. Good morning to everybody. I'm very happy to be here. And I was asked to delineate the process of individual communications at the CRPD committee. I've served as rapporteur on individual communications on the committee for 6 years and have been doing the cases in that time period. I will now share my slides. Let me, this one, share. Is this fine now?
Yes, we can see them.
Okay, very good, thanks. So the individual complaints procedure is a quasi-judicial procedure to the CRPD committee in which the CRPD committee sits as a court. It's available from those countries that ratified the optional protocol to the convention, which is today stands at 180 countries that ratified it to this day. Most EU countries in the EU, the Netherlands have not ratified it, then Romania and Bulgaria, and on the broader European level, Norway and Switzerland and Poland, by the way, have not ratified it either. The EU has not ratified it either. I will come back to that because ratifying the optional protocol to the convention by the EU would probably entail some changes to the jurisprudence we just heard from Bart on standing of organizations on the EU level. So now let me begin and get you through our process at the committee. First, the legal basis that you have you will find them first in the optional protocol. Articles 1 and 2 of the optional protocol clarify who has standing to sue. I will come back to these issues shortly. And what are the requirements for admissibility. Then we have quite detailed rules of procedure. And in the individual complaints procedure, particularly rules 55 to 78, we've revised them recently, this spring, in fact, and aligned them with the rules of procedure of the other committees, of the other treaty bodies, so that authors, as they're called under the treaty body system, do not have to deal with many different types of rules of procedure, depending on the treaty body they are getting to. We also have a few rules in the working methods, but those are really just a few scattered rules. Now, who is involved? First, of course, the state party. This is the entity against whom you file the complaint. Then the author, this is the complainant or whatever you might call that person. You have the petitions unit at the committee. The petitions unit is the administrative part at the Office of the High Commissioner of Human Rights that prepares decisions. This is the body with whom you as authors will interact. Then we have third interveners. If time permits, we'll come to that. There's a possibility that third parties can intervene in procedures to which they are not a party, in order to clarify for the committee certain points on how to decide. Then in the committee, we are structured on 3 levels. There's the rapporteur. The rapporteur on communications is the person most intimately involved with the cases. I'll come to that later on. Then we have a working group on communications, consisting usually of 4 to 5 people. Those are committee members that prepare the decisions for the plenary. And then we have the plenary, all 8 members of the committee that finally decide on admissibility and on discontinuance and on the merits. So how is this process going about? I will skip the next slide. The first step, once you file your complaint, is registration. The case needs to be registered by the committee, and registration is done by the rapporteur based on the submissions by the petitions unit. Prerequisites for registration is that the formal requirements for the complaint must be fulfilled, and there must be at least some plausible claim that's been brought forward. There is already at this stage a certain substantive evaluation of the case. Registration also at the same time, usually, although not necessarily, the rapporteur will also decide on interim measures and protection measures. And this is quite important. Interim measures are quite important in cases where you need to prevent the state party from taking action that might cause irreparable harm to the author. We very often have interim measures in situations where, in cases of non-refoulement, we have quite a few non-refoulement cases from Sweden, where deportation orders were issued, and we impose recommend interim measures in order for the deportation orders not to be executed until the committee decides the case. Now, the prerequisites for issuing interim measures are first irreparable harm. Then you need to have a certain level of severity of the infringement on a right in order to recommend interim measures. In non-refoulement cases, where you usually have the prohibition of torture and inhuman or degrading treatment or punishment, this level, of course, is usually reached. However, in other cases, we've had, for example, in education cases, we did not order interim measures. There's also a substantive evaluation. Some probability of success needs to be detected in the case. Now, we are mindful of the fact that in some situations, the interim measures might decide the case de facto. In education cases where you have a person maybe 8 years old, doesn't get the proper schooling, with an interim measure, you would de facto decide the case, because by the time the committee decides it, which is on the average a little under 3 years, that person will already have reached an age where the case has become moot. So interim measures are very important to request. I, as a litigant, would always request interim measures. Nothing negative can happen to you if the committee decides not to issue them. Then, very important, third-party submissions, third-party interveners that can clarify the case for the committee. Now, third-party interventions can happen at any time. You usually request them very early on. A third party can request it. The rapporteur will decide on whether the request is granted. What needs to be the case is that a third party submission must provide additional information for the committee to decide the case. Third party interventions are usually not allowed if they only propose one sort of interpretation by the convention that doesn't add anything to the committee's knowledge of the case to decide it. Then another aspect are split decisions. We have the possibility to split between admissibility and merits decisions. These requests come from state parties. No author has an interest to have a split decision. The consequence of dividing admissibility and the merits into two different procedures is that if you have a case that prima facie looks quite weak on the merits, you might want to restrict the further proceedings to admissibility questions, to have the exchange of views between state parties, the committee and authors confined to admissibility questions. So this is something as an author you do not support, because it works to your disadvantage. The rapporteur decides on requests for splits. Then, of course, admissibility. Who has legal standing? Article 1 of the optional protocol says that complaints can come from or on behalf of individuals or groups of individuals. Now, this is quite a difference to what we've heard with respect to the European Court of Justice. Now, of course, the author, him or herself, can file a complaint. In addition to that, an organization such as Validity or any other organization or even any other natural person can file a complaint on behalf of individuals or group of individuals. And this is why I'm of the opinion that if the EU ratified the optional protocol, the Court of Justice probably would have to adapt its jurisprudence on legal standing that Bart explained, because if they kept their rules on legal standing as they've developed them, they would be narrower than the ones that we have further up. Now, you do not. Any organization that files a complaint on behalf of persons with disabilities needs to show that they made all reasonable efforts to get the consent, the explicit consent from the persons on whose behalf they filed the complaint. However, if those reasonable efforts are not successful, we also accept individual complaints on behalf of persons with disabilities without their express consent. Why? As Stephen can tell you, if you have persons with disabilities locked up in institutions under a guardianship regime and the guardians refuse to act, maybe the director of the institution is their guardian, those are things that happen, then you will not get their consent because they will not, the institution will not let you to get into contact with them. So we have quite we have legal standing rules that differ substantially from what we usually see on the domestic level. Then we have, of course, admissibility issues or admissibility requirements. They are in the Article 2 of the section of the optional protocol. Must not be anonymous, no abuse of right. The same matter must not have been examined under another procedure. So be aware that if you first file a complaint with the European Court of Human Rights because they issue binding rulings and you lose, you cannot come to us with the same matter. Now, it's a bit more complicated than this. The European Court of Human Rights must have examined your complaint on the substance, a requirement that led the European Court to change its standard what you call them, the standard sentences for not taking the case on. You can bring the same case to our committee if you invoke different matters. So it really depends whether it is the same matter or not. The jurisprudence there is somewhat oscillating. Very important, exhaustion of domestic remedies. You need to have exhausted all domestic remedies that have a reasonable chance of your claim being effectively taken up and examined on the merits. Now, the committee's jurisprudence here is quite lenient. When you look at the case of Rekasi against Hungary, we deemed that the requirement of exhaustion of domestic remedies is fulfilled in a Hungarian case in which the civil court of first instance held that because a person was under guardianship, the guardian's actions were within the law. We thought that because guardianship laws are so deeply entrenched in many European countries, including Hungary's, that it would have been no reasonable chance of success to further go through the domestic court system. Also, if you file too early, before you've exhausted all domestic remedies, and you get the non-admissibility decision from us, that non-admissibility decision can be revised once you've gone through all the domestic remedies. In my experience, this has never happened yet, but I think it's because nobody has ever tried. Then, very important, you need to substantiate your complaint thoroughly. We will only hold those parts of your complaint admissible that are substantially that are sufficiently substantiated, and that requires you to have a very good understanding of the provisions that you invoke. We've had some cases in which authors fundamentally misunderstood Article 12, the right of equal recognition before the law, and then those Article 12 complaints were held inadmissible. So admissibility is decided based on each complaint that you file. Each complaint will be looked at separately with respect to its substantiation. And of course, the facts need to be have occurred prior to the ratification of the optional protocol. A sort of exception applies where facts started earlier on, but are continuing now. So this is very, very briefly going through the admissibility procedures. Then we decide on the merits where your substantiation is absolutely crucial. This is where the main gist of your complaint needs to be at. We issue recommendations we split them into two parts: specific recommendations with respect to your case, what we recommend that the state party is doing with respect to your case, and then general recommendations. If we detect a systemic problem that your case reveals about the nation's laws, the nation's legal system, we will also issue general recommendations to change the legal system, to change the law. So you might take this into account when you argue your case. And then if you want to look at some of the case law, I've put those cases on the list here that I myself find most interesting and most consequential. You can find them on juris.ohchr.org. All the cases can be found there. It's a web page for all treaty bodies, individual communications. You choose the CRPD, you can choose the country, or you can just choose the CRPD. That's usually enough because we don't have that many cases that not as many as the Human Rights Committee, for example. You can go through them. This gives you quite a good overview of some of the really important cases. So I think I've already exhausted my 20 minutes. Thank you very much.
Thank you very much, Markus, for this very interesting presentation. I'm sure there are people in the audience who are very much interested in perhaps bringing complaints to the CRPD committee, and this really helps them navigate the process, which sometimes is complicated. And that also makes me think your just mentioning of the cases at the end makes me think that it might be useful to organize sometimes a webinar on the actual case law and discuss the cases into detail. So for the participants, if there's such interest, please let us know, and we will be happy to facilitate such a webinar in the future. But for now, I would like to give the floor to our next speaker, Professor Gerard Quinn. And Professor Gerard Quinn is the former UN Special Rapporteur on the rights of persons with disabilities. Professor Quinn lives in Ireland, and he's also Professor Emeritus in Law at the National University of Ireland in Galway. He currently sits on the Scientific Committee Advisory Board of the European Union Fundamental Rights Agency. He has also directed large studies for the UN Office of the High Commissioner for Human Rights and led the delegation of Rehabilitation International during the drafting of the UN CRPD Convention. Professor Quinn will talk today about a case that was actually litigated by Validity before the European Court of Human Rights. That is the case of TJ versus Hungary. And he will be discussing how this case has shed a light on invisible persons and the hidden issues that this case hopefully has brought forward, and perhaps some things that remain still to be litigated. Professor Quinn, I hope you can see us or me.
Yes, perfectly. Thank you so much, Simona. What a wonderful seminar. And thank you very much for the invitation to speak. I will try and share my screen with the caveat that I'm not great on computers. Bear with me one moment. Let me try one more time. Here we go. Okay.
Yes, it works. We can see your screen.
Thank you so much. Just a preliminary word at the outset. I used to teach a seminar series on theories of judicial activism. So I'm quite fascinated by the role of courts in the broader ecosystem of change, but also how do you assess a particular outcome or a particular decision? I tend to view such decisions, whether they're negative or positive, never as an end point, but always as a departure point in a broader narrative about the process of change. So I decided to just focus on one case, It happens to be a case in Strasbourg before the European Court of Human Rights, but it does have EU implications, and I will come back to that later on toward the end. The kind of strategic litigation we're interested in tends to focus on a category of persons who find their humanity discounted for one reason or another, or hidden issues. And these are not so much issues hidden completely away from sight. They're before everybody, but nevertheless, they don't register as important issues. So one of the fascinating things about key strategic litigation is it brings the salience of these issues to the top table, whereas in fact, they may have relished somewhere else. How do I move on here? Now that I've opened it up, how can I actually move on? Just one, bear with me. Okay. So I want to just cover three things in my presentation. First of all, I'd like to just take a back seat for a moment to discuss the distinction between law and politics and situate strategic litigation within that continuum. I think it's incredibly important. Secondly, I want to focus on the case at hand, validity on behalf of TJ against Hungary. The fact that validity was involved is coincidental. I'm really interested in the substance of this case. And lastly, how do you frame, how do you use such outcomes as a portal to actually reach other issues that have been neglected over time? So these are the three things I just want to cover very briefly. First of all, in terms of the distinction between law and politics, I think it's fair to say that the natural default within the political system is to avoid at all costs. So regardless of the merits of the issues, the political system does not naturally reach the kind of issues that we want them to reach. It's kind of built on the naturalistic fallacy that whatever is what ought to be. So don't challenge what the existing system is. And policymakers, politicians will tell you whatever, but the policymakers who are the key gatekeepers, they tend to see the cost of change. They don't tend to see the merits of change. And they tend to see the collateral byproduct of change. In other words, if you give it to people with disabilities, maybe older people will start claiming it too. So we got to put a stop to this crescendo of social demands for change. And the merits tend to be buried, and therefore change is very haphazard. So the question naturally arises, are courts any different? And I would say they're not. I would say, in fact, they're, if anything, more conservative than the political branch. Their capacity to mirror social change is somewhat less than the political branch. And of course, legal elites tend to be highly conservative in their training, in their socialization, and in their behavior. The one thing you have going for you in the legal system is we have to pay attention to the facts, and we also have to take norms seriously. So sometimes that means taking persons seriously and taking the issues seriously. However, and I would say this is a big caveat, persons can still be discounted by courts and issues can easily be avoided. Bart was looking at some of those earlier on, what's called the passive virtues of judging. The issue is moot, the issue is too political, not sufficiently legal, etc., etc. So you need to be able to present the case so that the persons, their existence, their conditions, their status cannot be ignored by the court. Now that's easier said than done. And you need to make the court comfortable facing the issues and facing the facts, when in fact their first instinct might be to ignore them or to defer the issues back to the political branch. So I'm very much a legal realist. These are the challenges you have to overcome, regardless of the merits of the case, in actually punching through at the level of the court. What's the case study? The case study is the recent decision of the Strasbourg Court on validity on behalf of TJ against Hungary. It has everything. It has invisible persons, long stay residents in institutions, what I would call legally disappeared, in the sense that their legal capacity was stripped away from them. And you have hidden issues. And the hidden issue I want to get at is the death of these residents. There's an amazing statistic from the medical school in UNSW in Sydney that people with intellectual disabilities, whether they're in institutions or living in the community, die 20 years earlier than their peers. Quite fascinating. And it should send off all sorts of alarm bells, not about the natural causes of these deaths, but what are the systemic causes that have to do with a lifetime of inequality and poor treatment. Usually these deaths are put down to natural causes, when in fact many of them are anything but natural. And this is what this case is really all about to me. Even if investigations, medical investigations, coroners' investigations get beyond natural causes, there is an inbuilt, what I call synchronic bias. You only look at the last proximate medical cause of death. Your frame is too narrow. It doesn't encompass the impact of equality over a lifetime. There are international standards out there on how to properly investigate such deaths, but guess what? They're not applied to marginalized groups, whether it's people with disabilities or older people or other people in similar situations. So the issue really highlights the interdependence of rights, the civil right to life, with economic and social conditions for life to make it optimal. What was the facts of the case here? Well, Ms. TJ was born in 1973 with a severe intellectual disability. When she was 10 years old, she was placed in the Topaz social care institution, notorious for many historical reasons. She was deprived of her legal capacity, placed in the guardianship of her mother, and eventually that guardianship was placed in the director of the institution. As Markus intimated, this is quite a common phenomenon, particularly in Central and Eastern Europe. Toward the end of her stay, her guardian was guardian for multiple residents at the institution, and there's some evidence in the case that the guardian only visited episodically in the institution. And this gets back to the question of avoid, avoid, avoid. There was report after report after report, whether official or semi-official or private, about the atrocious conditions within the institution. Chemical and physical restraints were reported. By the way, this is common across the intersection of people with disabilities and older people as well. And even a doctor recommended that she should be restrained while lying in bed due to the low number of caregivers. In other words, a direct link between the conditions of life and her actual right to life itself. So the facts were well known. Everybody knew these facts, but yet nothing was done. Medicine and food past their expiry date was found. Care records were incomplete. She was transferred to hospital where she was diagnosed with pneumonia, and she was, when she was about to be released, her condition deteriorated and she died August 2018. An autopsy was carried out and the cause of death was described as bacterial pneumonia. In other words, the investigation only looked narrowly at the proximate cause of death, not at the actual impact of the conditions that she had to suffer for many years. There was actually evidence of similar deaths, that should have aroused suspicion and set off alarm bells, but they were ignored. So the narrow focus was just on the proximate cause of death. Validity brought this claim before the Strasbourg court, and I won't get into many of the preliminaries and the other issues at stake, but the heart of it was Article 2 under the European Convention, the right to life. She was placed in a state-run social care institution, had died there from long-term neglect and inadequate care, not from pneumonia, but from the impact of this long-term neglect. They also claimed, Validity also claimed, and this is really important, that the investigation, the medical legal investigation, had concentrated on potential medical negligence on the part of the personnel, had not concentrated on the potential medical negligence on the part of personnel in carrying out the duties, and had not addressed the question whether the death had been caused by the inadequate conditions of the social care home. In other words, the investigation was improperly configured. It was rigged not to get at the right issues in this particular instance. It was further claimed by Validity that the authorities failed to address the systemic deficiencies in her care and adopt appropriate measures to safeguard her life. And Validity argued that the investigation had been insufficient since it had not inquired into the circumstances of her care and the use of physical restraints which could have contributed to her death. Right. The court's ruling was fascinating on this point, at least. The court observed that according to the autopsy, she had died of pneumonia. While this clarified the direct cause of her death, the court refers to its finding, blah, blah, that the domestic investigation failed to address the systemic failures in the care system, which been had reported on by a number of actors, including the state itself. So in other words, the court was implicitly, at least, of the view that the lens for the medical legal investigation was far too narrow and it failed to get at the true causes for the death over time, which was the neglect and the want of care in the institution. So I think this is really fascinating. I think the court's ruling you can consider as a portal, as leading to other issues which have been long neglected. For example, ever since the 1980s, the right to life has always been dealt with under various treaties in terms of substance and process. By substance is meant the obvious, do not kill, etc., etc. Process is fascinating because in the late 1980s, early 1990s, what we had then were the end of the Cold War, the transition from authoritarian to democratic states, although that's still ongoing, a lot of problems with terrorism, a lot of problems with disappearances of people, and a suspicion that they were killed while they were being disappeared. So one of the arguments of a lot of, let's say, bad states before international tribunals is there's nobody you can't prove a case of killing. And the international tribunals responded by saying, where there's no body or where there's a disappearance, it's up to you to properly investigate that disappearance. And that is the so-called process dimension to the right to life. But guess what? Those process dimensions were never applied to marginalized groups like people with disabilities and older persons and others. They could have been, but they weren't. These treaty obligations led to what's called the Minnesota Protocol on the proper investigation of quote unquote suspicious deaths. Very sophisticated standards but never actually applied to people with disabilities or other marginalized groups. And by the way, there is now a partner instrument called the Istanbul Protocol on the proper investigation of torture, cruelty, and other forms of unfair treatment. That too is full of implications as applied to persons with disabilities, but it's actually never been applied to people with disabilities. The requirements of the treaty bodies with respect to the process dimension to the right of life include the obvious ones, like the body doing the investigating should be fully independent, it should be transparent, it should be capable of processing the evidence, a large amount of which is forensic. And actually the Minnesota Protocol has very detailed guidelines on forensic investigations. There ought to be full family involvement as well as full publicity to make sure that the rule of law is being respected. So I'll conclude here. How do we use the ruling in TGA to unlock the potential of the Minnesota Protocol and other instruments like it? I think we need to, first of all, purge our ableist assumptions about natural causes in investigations. There is a lot of interesting public inquiries around the world, famously in South Africa about 4 years ago, where nearly 200 people died as a result of a botched deinstitutionalization program. A lot of the death certificates put the deaths down to natural causes, but the various public inquiries said this was a lie. They were not down to natural causes. It was a result of the botched deinstitutionalized programs. It's very important to configure all investigations, whether done by medical legal entity or by a coroner's entity, for example, in the common law system, to probe the underlying systemic causes. Sorry, let me go back. And that's incredibly important. Let me just go back one, sorry. Technology is great when it works, but when it doesn't work, and that's possible, and I'll come to that momentarily. And litigate when they don't. Force these bodies to actually broaden their lens to look at the accumulative effects of inequality over time. Most importantly, and there are a number of examples around this around the world, use that information to actually change life circumstances for the living. So if we can understand what some of the systemic causes are, we should use that to prevent avoidable deaths into the future. Now, this is important because with respect to, for example, deinstitutionalization, governments will say, oh, progressive achievement and all the rest of it. Well, they can't say that when it comes to the right to life. It's much more morally and legally and politically urgent that these preventable causes are actually removed. There are EU directives on medical investigations. I haven't looked in them in any great detail, but I suggest there may be a hook or two in there to actually litigate before the European Court of Justice on how these investigations are configured, and more importantly, how the knowledge is used or not used by governments, as the case may be. I think the CRPD committee should draft a general comment on the right to life, emphasizing the dependence of the right to life on the conditions for life, and highlighting the duty to reveal systemic causes of death and to rectify them. There's a number of examples out there around the world. For example, the prevention of future death reporting in the UK is quite well advanced since the 1980s, to their credit. There is a very significant NGO in London called Inquest, who have very many recommendations to improve that system. The Australians and the New Zealanders have a joint database, which is mined periodically to detect systemic causes and then to influence the policy process in rectifying these causes. By the way, in the UK at the moment, it's my understanding that every death of any person with an intellectual disability, whether in an institution or in the community, must be investigated. There's a site of expertise in this in UNSW Medical School, but more of that later. Last but not least, let me show you the last slide if I can get to it. I published with the International Disability Alliance about 3 months ago a very large study on this, which is called Inequality in Life and Death, the duty to investigate and remedy the systemic causes of the death of persons with disabilities under international law, a life course perspective. A much shorter version of this will be coming out in one of the law journals shortly. So with that, I hand it back to you, Simona, and glad to answer any questions.
Thank you very much for this presentation. It was really, really interesting. And I think it was interesting for us as well as organization who litigates the rights of persons with disabilities. And I hope also for our audience who might be interested in litigation to hear what the added value is and how you can bring, how litigation can bring hidden issues into sight. And I have to say that from our own perspective at Validity, we do see that a lot. I completely agree. Courts are usually conservative fora. They're not so open-minded, but the advantage of courts is that they take facts into account, as you said, and they look how norms have been used in concrete circumstances. And this in turn, we hope, can help further advocating for the rights of persons with disabilities, because it makes the invisible visible. That is my short take on your presentation. Thank you again for it. I would like to now open the floor for questions from the audience. Please feel free to write them in the Q&A section, and you can also simply give us your questions here in by simply unmuting your microphone. I will start by reading out the 2 questions that we have now in the chat. I think that both of you, both Markus and Gerard, could answer these questions. And before that, Markus, I would also have a question to you, and this is related to the comment that you made on the individual communication procedure and the role of the EU there. And my question to you would be whether you think the EU could ratify the optional protocol on a communication procedure without changing the treaties, whether such a thing would be possible, or whether it would be necessary to first change the EU treaties and then to ratify the optional protocol. This is my question. I will then read these 2 questions in the chat, and perhaps I will give each of you the floor afterwards. So the questions in the chat are from Anna. She's asking, do other UN treaty bodies collaborate with the CRPD committee to exchange developments regarding Article 12 with international human rights law? We have observed that certain UN treaty bodies appear to adopt significantly different interpretations of legal capacity in relation to persons with disabilities within their respective jurisprudence. Are there any developments or ongoing efforts aimed at harmonizing the interpretation of legal capacities across different UN treaty bodies? This is one question. And Anna has another question, which is, when do living conditions reach the threshold of constituting a systemic cause that adversely affects or violates their right to life? I think this second question definitely is addressed to Gerard, but I'm sure, Markus, you must have some thoughts on it as well. And perhaps before you start answering these questions, I will give the floor to Emma, because I see that her hand is raised, and you could ask your question, Emma. You have the floor. Emma, can you hear us? Can you see us? I see that okay, there I see. Or perhaps it was, she didn't mean to raise her hand. In case you did mean, Emma, please feel free to speak. Otherwise, I will give the floor first, Markus, to you and then to Gerard. Thank you very much.
Yes, thanks, Simona. To your first question about a need for the change in primary law, I don't think it would need a change, because when you look at the judgment that the ECJ rendered with respect to the EU joining the European Convention, the main issue was that the relationship between the two bodies and then between the two courts would be unclear. And this would be somewhat different when ratifying the optional protocol to the CRPD Convention, because we do not render binding judgments. Our views, our communications, our recommendations that in the end leave it up to the European Court of Justice on how to go about these recommendations, what to do with them. Now, when we look at the states courts jurisprudence on how they deal with recommendations in individual complaints procedures, it varies extremely widely. You have some courts that follow them by the letter. Swedish courts and Swiss courts usually follow recommendations in individual complaints procedures without exception. We have a somewhat mixed result from France. We have, with respect to the CRPD Convention, a very negative position from the UK courts that hold, because there is no implementing legislation, these recommendations are meaningless in adjudicative domestic procedures. And then you have countries that simply ignore them, like Tanzania. So it would leave it up to the decisions by the European Court of Justice on how to give effect to recommendations. And I think that would make the situation substantially different from under primary EU law, different from the European Court of Convention on Human Rights. Then on the Article 12 jurisprudence, no. The short answer is no. There are no ongoing efforts to harmonize the committee's jurisprudence on legal capacity of persons with disabilities among the various treaty bodies. We are very much aware of the differences in jurisprudence. We see a stark reluctance from the side of the Human Rights Committee. CESCA Committee is much more open. CRC too, although there with children the situation is different, because you can have substitute decision making with children even under the CRPD. You cannot have substitute decision making with adults, and CEDAW is more open as well. So, but we do not at the moment have any internal processes, ongoing processes to alleviate, to align the jurisprudence. This is one area. It would be very difficult to reach consensus. We've seen that with respect to the question of institutionalization of children with disabilities, where we had long, winding meetings with the Committee on the Rights of the Child that didn't really lead to the results that I would have liked. So those are the two questions. When do living conditions reach the threshold of constituting a systemic cause that adversely affects or violates the right to life? I think when you look at systemic issues, one thing you might want to look that doesn't answer it conclusively. But one thing you look at it is the normative framework regulating the area with which you are dealing. When you look at living conditions, one thing you would look at is first just what are the legal protections and the legal guarantees of living conditions in institutions and in other places of detention. And then once if you don't have any, that's already a sign that there might be a systemic problem behind it. Because just leaving it up to the individual institution, I don't think is sufficient, even though the European Court of Human Rights uses language that you can interpret differently. And then we at the committee are dealing with systemic causes or systemic violations in the complaint in the inquiry procedure under Article 6 of the Optional Protocol. And under Article 6 of the Optional Protocol, in order to start an inquiry procedure, we rely on closely or on a dossier that deals with that shows individual cases on a mass basis. And once you have you can detect a certain pattern from well-researched and well-documented individual cases, that of course also gives rise to the suspicion that there might be a systemic problem. In the inquiry procedure, we then of course try to verify or falsify the assertions with our own visit to the state party.
Thank you, Markus. Thank you for this. Gerard, would you like to come in? Thank you.
Yes, thanks very much, Simona. Anna, what a wonderful question. Your question was, at what point do deficiencies in living conditions amount to a systemic cause that triggers a heightened series of investigations? Very, very interesting question. Up to now, there's been an academic discipline called epidemiology in medicine, which is really about the prevalence of various conditions, life-threatening conditions, so forth. There's now an academic discipline of social epidemiology, which is really about the balance of advantages and disadvantages faced over a lifetime that have an impact on morbidity and mortality. It's an absolutely fascinating field. And I would also say that the prevention of future death reporting by coroners in the UK are absolutely fascinating. They're all online. Many of them are covered in our study a few months ago. For example, many of them cover gaps in services, critical gaps in services, poor administration of services in the community, and not just conditions within institutions themselves. They make for absolutely fascinating reading. One of the deficiencies of the British system is there's no oversight mechanism to make sure that the policy recommendations that ensue from these investigations are actually tracked, monitored, and implemented, but that's another day's story. What all of this reveals is a fascinating element in the jurisprudence before the African Commission and the Inter-American Commission, who draw no distinction between life and the conditions for life. Absolutely fascinating general comment from the African Commission about 5 years ago on exactly this point. When you think about that, that's really another way of saying civil rights, in other words, the right to life, is interdependent with economic, social, and cultural rights. And of course, the CRPD is famous for blending the two. So there ought to be many possibilities there. But great, great question. Thank you very much, Anna.
Thank you, Gerard, and thank you, Anna, for this question. I think it's also very good food for thought for us, and it will help develop our strategies when we claim violations before international bodies. I would like to follow up with another question that we received in the chat from Emma. She is asking the following: considering the fact that standing in front of the CGEU remains a substantial issue, to Mr. Schefer, as you mentioned, the rules of standing would have to be changed if the EU ratified the OPCRPD. Could you provide some thoughts on what these new rules would look like according to you? This is the question for Markus. And for Gerard, the question is, could you provide some reflections on how the rules for legal standing of persons with disabilities at the European Court of Human Rights could be used by the CGEU if it needed to change its rules on standing? Would you like to come in, Markus?
Yes, please. Thanks for following up on this. We have the requirement of exhaustion of domestic remedies for complaints with the CRPD committee. Now, what you generally want to have is a system where the lower instances have at least as wide where the rules of standing at lower instances are at least as wide as those on higher instances. You don't usually open up at the top and keep it narrow at the bottom, because that the reason for one reason for the requirement of exhaustion of domestic remedies is to give the state party, and if the EU ratified the EU, the possibility to rectify a problem on their own without giving it up to the international level. They would lose that possibility if the EU courts' legal standing rules were narrower than ours. So I would think it would make perfect sense to widen standing rules in cases that could eventually be brought to our committee, at least as much as wide as our standing rules at the committee are, so that you're not narrow lower down. It would remain up to the EU and the ECJ to do something with that. To do that, it would not be a legal mandate to do that, but it would probably not make much sense to just not involve their own courts in cases that can be brought to the committee.
Thank you very much, Markus. Gerard, would you like to come in, please?
Yeah, just very quickly, let me emphasize that since there is a continuum or a dialectic between the right to life and the conditions for life, litigation before the European Committee of Social Rights is just as important as litigation before the European Court of Human Rights. I just thought I'd make that general point. The European Court of Human Rights has been nudged over time to loosen up standing in order to allow entities like Validity with a bona fide interest in an issue where somebody otherwise could not mount an action to actually mount that action before the Strasbourg court. But given that Luxembourg and Strasbourg are rather jealous of one another, I don't think there would be any automatic transferal of jurisprudence from Strasbourg to Luxembourg. I wish it were so, but I don't think it would happen.
Thank you very much, Gerard. And thank you both of you for your very interesting contributions. If there are no more questions, I would like to thank you and to move on with our closing remarks by Stephen Allen, Validity's Executive Director. And I don't think Stephen needs any introduction here. But we are happy to hear you, Stephen, with some reflections on the webinar today and perhaps on the wider role of strategic litigation for persons with disabilities and how we can make an impact and how organizations in general can make an impact in this field. Stephen, if you see me or if you hear me, would you mind coming in? Thank you very much.
I do, Simona. Thank you very much. Good afternoon as it is now, friends and colleagues. Firstly, Simona, thank you to you for your wonderful work to bring us together on this really, really brilliant project. I also just want to quickly shout out two of my colleagues sitting in this office, but with their screens off, Cengiz and Axel, who are supporting this webinar behind the scenes. We're deeply indebted to all of the incredible speakers we've heard today, and for throwing a light, I think, on both our successes and the challenges in pursuing legal claims that aim to achieve systemic change for people with disabilities. And if you'll bear with me, I'll just point out a few points to start with that particularly struck me. Bart, I think you're still here. You reminded us how strategic litigation is messy, but a team effort. And also that judgments are just one part of a much longer journey. We are so indebted to you for your expertise around European Union law, your colleagues at Covington, and how much commitment you've had to helping us push the limits of what is really possible to give effect to the CRPD within European Union law. I definitely look forward to more of that brainstorming with you. And hey, a treaty change really should be on the book, I think. Secondly, Kara, I think you are still here from the Greek Council of Refugees. I want to thank you for giving us an insight into your own incredible work on using EU law and other mechanisms to promote legal and policy change. I was struck that many of your legal goals are very similar to ours, even though we seek to support different populations. You're focused on promoting legal and policy change. You're focused on enhancing transparency and accountability. You're focused on enforcing human rights standards within the EU corpus. And I think we have a lot that we can share and learn from your incredibly important work. Markus, if you don't mind, and I hope you won't, I want to thank you in particular, but also the entire Committee on the Rights of Persons with Disabilities for your crucial and hard work on overseeing global implementation of the Convention. I have to say, your committee's most recent concluding observations to the EU were so clear and strong, and I think you've set out a very clear path to the Union on how it needs to do so much better in implementing its obligations to European citizens with disabilities. Like the CRPD committee, my hope at least is that the Court of Justice of the EU won't just shut its eyes to people with disabilities who, as you point out, cannot access the doors of justice so often when they are locked in institutions, they're under guardianship, and when they face all sorts of barriers to even being heard. So thank you so much. And Gerard, it's been so good to listen to you, and thank you once again, and for many years, reminding us how important it is to step back and see where we are on this much bigger journey. I think you've reminded us so well that litigation is about bringing crucial issues to light and facing decision makers. In essence, we're trying to bring life into the legally disappeared to remind those in power that they have a duty to act. Cases, as you've pointed out, are merely a point of departure within much wider processes of social, political, and cultural change. And I think what you also remind me of is that courts are not just adjudicative authorities, but are actors themselves within broader processes of change. Our litigation is not only about achieving redress for our clients, but can also educate the justice system itself on how to become more inclusive of people with disabilities. But I also take your point that we need to purge our courts of their ableist notions before they can actually address the systemic issues that so often cause persons with disabilities so much harm. I have to say, and if you'll bear with me, your work on the right to life is particularly close to my own heart, as I came into this world of disability rights, having lost my own mother in a situation in a psychiatric hospital where systemic failures were at the heart of the reason that she passed away. And only now, 20 years later, we begin to see effective judicial recognition of these issues. So thank you so much for your work. Over the last quarter of a century, our team at Validity have been dedicated to developing and pursuing an extensive range of legal strategies, as you've heard, on the rights of persons with disabilities. And we've done that here in Europe, but we also work in Africa and are increasingly receiving requests worldwide from organizations of people with disabilities. We and our partners have explored and pursued national and international remedies for victims of inadequate laws, abusive policies, and practices that deny people with disabilities their rightful inclusion in our communities, their equality before the law, and their access to justice. Navigating barriers to access to justice has been a consistent theme today, and I think is a constant theme of the work at Validity. While we've had some notable and important successes, some of which you've heard about today, it would be remiss of us not to reflect on the huge challenges that continue and remain. All too often, people with disabilities are still met with inaccessible and inflexible courts, inflexible judges, and other authorities in their day-to-day life and when they seek justice. All too often, judges and lawyers have very limited knowledge of binding international human rights law. They so often fail to give effect not just to the letter, but to the spirit of the rights enunciated under the CRPD. The road to justice and freedom, as they say, is extremely long and hard. But I want to say at Validity, we are acutely aware also of the personal toll that long-term legal strategies can have on our clients. We are incredibly indebted to them, to their families and loved ones for working with us over these 2.5 decades and beyond, using the experiences in their lives often to fight for change that will benefit for so many others. The law has a crucial role to play. It can not just advance the rights of people with disabilities, but hold to account those who have the power to make real changes. This doesn't include just state parties to the CRPD or member states of the European Union, but increasingly, Validity is focused on other authorities, including the European institutions themselves that have such an important role to play in guaranteeing the rule of law, democracy, human rights, and inclusion across this continent and beyond. What can we achieve with our ongoing strategic litigation in the shorter and longer run? We've heard a few ideas today, and so I want to give you a few of mine. The first relates to authoritative recognitions of rights. Whereas in the disability movement, many of us have perhaps become accustomed to advocating for core concepts such as the right to legal capacity, equality before the law, and independent living in the community. We must also acknowledge that these rights and concepts are poorly understood by very many duty bearers, by legislators and policymakers. In some cases, I think Gerard said this, they are simply forgotten about. Specific judicial or legal recognition of these rights-based claims can serve as the basis for broader reforms, changes to laws and policies, and can serve as a reminder for duty bearers of their obligations. It can increase accountability for public officials, making them more accountable to their citizens with disabilities. Secondly, there's an aspect of triggering those systemic reforms themselves. When our legal systems are brave, they can actually go beyond adjudicating narrowly defined claims, and can sometimes even become aware of the crucial role that they themselves play in triggering more fundamental change. What do I mean? When the European Court of Human Rights is on form, if you will, it can indicate what have been referred to today as general measures to respondent states. In essence, this is when the court recognizes a systemic problem. It's a Houston, we have a problem moment, and can set the direction for those more far-reaching reforms that will be necessary to prevent future violations. The court does this in many cases, and most recently in one of ours, in the judgment of VI against Moldova, a case concerning a child with an intellectual disability who was locked in an abusive adult psychiatric facility and denied any support in the community. The Houston moment, if you'll have it, was when the court recognized that our client had been discriminated against both on the grounds of age and disability, and went on to tell the state that it had to fundamentally reform its approach for persons with intellectual disabilities, for children, and to end this abusive practice of keeping such people involuntarily detained and placed in psychiatric facilities. While the court also in that case noted there was a lack of support to families, it could and probably should have gone further in telling Moldova in this case how to redress that. Nevertheless, the declaration of general measures means we can now monitor the progress, that the Committee of Ministers of the Council of Europe will continue to be seized of the matter, and we can continue pushing for concrete policy change. I was also very interested to hear today that the CRPD committee has a similar approach with the possibility of indicating general measures. Thirdly, international litigation can act as a catalyst. It may not always yield immediate results, but it does plant seeds for those longer-term reforms that we require. When we approached the CRPD committee to inform them of systematic violations of the rights of persons with disabilities in Hungary back in 2017, we knew that the establishment of an inquiry under the optional protocol could be an important opportunity for a far more wide-ranging legal analysis of the country's twin carceral systems imposed on people with disabilities, that of guardianship and of institutionalization, both of which, of course, our client TJ was subjected to. The CRPD committee did find that these systems, which affect tens of thousands of people with disabilities in the country, amount to grave and systematic violations of the Convention, adopting their report in 2020. On its own, that decision didn't immediately marshal the Hungarian government into undertaking urgent reforms. But sure enough, it served as the basis for numerous other actions, some public, many behind closed doors, reinforcing the message to Hungary that enough is enough. Among the notable interlocutors were the European Commission, who got in contact with Hungary after the publication of the inquiry because they were deeply embarrassed and ashamed at the extent of EU funding that had been used to propagate these systematic violations. Now, the Commission, if I can say so, is well known for its timidity when addressing these types of issues publicly. In private, nevertheless, and we only found this out through pursuing freedom of information requests, the Commission began exerting substantial pressure on the Hungarian government to prevent EU money from continuing to build and maintain institutions in Hungary. We haven't stopped this overnight, but I think here you can see the links from the CRPD, or I should say from persons with disabilities here in Hungary to the CRPD committee, which was willing to open its eyes, through Brussels and back to Budapest. We have created, I think, a cycle where strategic litigation has begun to nudge Hungary in the right direction, a country which does indeed need some nudging right now. Now, I have spoken elsewhere, most recently on the sidelines of the annual UN Disability Conference in New York, at a side event coincidentally hosted by Professor Schefer, about the manner in which access to justice holds such a crucial importance to persons with disabilities. When people with disabilities can experience their claims being adjudicated with fairness and with a true grounding in international human rights law, it can have a transformative impact, not only on the lives of our clients themselves, but also for so many other similarly situated individuals. Access to justice really is about far more than just getting into the courtroom. At its essence, it is about the extent to which our societies truly value and give effect to the principle of equality. Equality before the law for persons with disabilities, equality as full persons, as full citizens, as full members of our societies. And Validity's litigation will continue to be grounded in this foundational value. These principles are at the heart of all international human rights and development documents and the foundation of democracy itself. And yet, while we continue to have a long way to go, we do need our courts also to step up to the challenge. Earlier in the session, you heard from Bart about our joint efforts aimed at engaging the Court of Justice in disability rights cases. And I have to be honest with you, it has been a hard and frustrating road. That international disability rights law is a core source of European law shouldn't be contentious, especially given the EU's own ratification of the CRPD. And while there is a long and complex legal and political history about the extent to which the EU itself is a community grounded in human rights, there is increasing recognition that such a broad and powerful union can only actually function where it expresses, protects, and fulfills the rights of its citizens and its own core values. Those core values are most succinctly stated in Article 2 of the Treaty on the European Union. And as lawyers, we like to start with these articles. Let me read it. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. Look, this is not just a list of rights or a checklist of items which member states and EU officials need to tick off when they are doing their day jobs. In essence, it's about the nature of the EU itself, far beyond the economic objectives with which the Union was originally established, and a recognition that our shared prosperity, at least on the European continent, can only be achieved where every person's rights are respected, protected, and fulfilled. The Charter of Fundamental Rights, having a superior status within the corpus of EU law, is the more extended version, mirroring to some extent more traditional sources of international human rights law, including, of course, the European Convention on Human Rights. However, you've heard today that there are some very important limitations, the most important of which is found in Article 51 of the Charter, meaning that fundamental rights, at least from an EU law perspective, only seemingly apply to EU institutions and member states when they are implementing union law. That limitation can and has opened up the door to fierce debates about whether and when so-called fundamental rights provisions apply and whether or not any impugned act is actually being taken by a wayward minister or European official in the context of implementing European law. Now, let me move close to some of my closing remarks by mentioning that the EU's highest judicial authority, the CJEU, is in fact increasingly being called on to give greater effect to both the Charter of Fundamental Rights itself, as well as Article 2 of the Treaty on the EU. Right here in Hungary, as I speak, the government continues to violate some of the foundational values of the Union, fundamental rights, no less. And the most recent example is its ongoing crackdown against minorities, including the LGBTQ+ community. Tomorrow, Pride has been banned. Now, is that ban operating within the scope of EU law? Does the European Commission have the legal basis to enforce the Charter of Fundamental Rights? Does the Court of Justice have the ability to enforce Article 2 itself? Tomorrow, we will test the Hungarian ban as we go out on the streets in Budapest. And immediately thereafter, I think the Court of Justice will be tested, whether or not it decides to enforce the Charter and to enforce the Union's core values. The outcomes of that case will have great significance, not just for Europe's LGBTQ+ citizens, but for all of us, including persons with disabilities, who do need an architecture to protect fundamental rights and give full effect to them. So far, the CJEU has remained reticent to put fundamental rights at the heart of its judgments. It has spent copious words and conducted legal gymnastics to narrowly define and interpret questions related to the scope of application of the Charter. This reticence, in part, is often justified with the famous principle of subsidiarity. And that principle, that reticence, is often mirrored by national courts within member states. As a result, cases that start in EU member states, including on behalf of people with disabilities, rarely invoke the Charter, and in very few cases do we actually get successful preliminary reference requests. So I'll close with a few thoughts to say that I think the EU needs to remain relevant for EU citizens in a time of real global crisis. It must deliver on the rights of persons with disabilities, and far better than it has done so thus far. This very webinar is happening under the framework of an EU scheme about raising awareness of the Charter. Now, that's noble, but it is a limited expression of the Union's commitment to fundamental rights. Actions do indeed speak louder than words, and so we do actually need to see the EU's own institutions, including the Court of Justice, acting on fundamental rights claims when they occur. Whether this is about challenging public financing of institutions or about striking down restrictions on the right to vote in European elections for persons with disabilities, we have yet to see real, bold action. As human rights advocates and lawyers, we need to continue with our strategies to bring life to disability rights. We also need to continue to work creatively to invoke the Charter within the EU in a matter that truly engages with the lived realities that persons with disabilities face, from ending public financing of disability segregation to guaranteeing equality before the European legal architecture. I think I've been clear. The Court of Justice does need to step up. Let me conclude now with a couple of directions that have occurred to me as we have spoken. Globally, disability rights and other rights are being increasingly difficult to pursue. This is due to political transformations worldwide, and we cannot ignore this hostile climate. Early next year, Validity will organise a global strategic litigation convening to build a longer-term strategy to defend the gains that we have had and also to prevent further attacks on people with disabilities. We will share this with you. Second, we'll continue working on creative and new litigation within and beyond the EU. One of the legal goals I'm most passionate about is getting an explicit judicial recognition that institutionalization on the grounds of disability itself amounts to a prohibited form of discrimination. This could open so many doors, legally and metaphorically, but also in reality. Third, we believe that the jurisprudence of the CRPD committee can be such a strong basis to inform broader legal strategies nationally and around the world, and we will continue bringing this to life with our global network of litigators. And finally, I noted in particular that there is an urgent need to address the divergences that have occurred between different standard-setting bodies, whether that's the UN treaty bodies at the Council of Europe, or indeed here in the European Union. Next year, we will bring together a range of seminars to bring together experts, just as we have done today, to address these divergences and advocate for a more coherent set of interpretations that will truly benefit people with disabilities, whichever legal system they are subjected to. With those remarks, I want to thank you all again. Thank you very much, Simona. Thank you to all of our speakers, and we look forward to continuing this long journey together. Thank you.
Thank you all. We have reached the end of this webinar. Thank you very much, Stephen, for these inspiring words. I hope that our audience has found inspiration in these wonderful panels that we've been having. So thank you everybody who has participated in this. My last words, with my last words, I would like to highlight that we will be having some more activities connected to litigation and strategic litigation. As part of this project, we will be launching a podcast series where you can hear more about strategic litigation and how persons with disabilities have participated or have been affected by strategic litigation. Please stay tuned and check it on our website. We will publish the link soon, and you will be able to download and listen to the podcast on Spotify. And we will be having an end of the year conference on 25 October in Brussels. And there we will be talking more about strategic litigation and how this project has unfolded. The last words would be to thank to the partners that worked with Validity in the project. The project has been coordinated by Victim Support Europe. We have worked together with European Network of Independent Living, with Kera Foundation, Forum from Human Rights, and Center for Legal Resources. Thank you all for your work, and please stay tuned to more activities on this project. For now, bon appetit. I think everybody's ready to eat, and see you all soon. Goodbye.